Partnership, from A Treatise on Business Law by Myron Tuttle Bly. Partnership. The contract. Partnership is a contract whereby two or more persons mutually agree to employ their money and labor in a common business and divide the profits and share the losses. They may contribute equal or unequal amounts of money. They may divide the profits and share the losses equally or unequally according to the terms of their agreement. If they contribute equal amounts of money and equal labor and skill, it is customary to divide the profits and bear the losses equally. Their common business constitutes the partnership, sometimes designated a CoPartnership, and they are called a firm. Formation of partnerships by written contract. If the business intends to be transacted is to be some moment and involves the contribution of a considerable sum of money, it is customary to put the contract of partnership in writing to be signed and sealed. The written agreement is called the Articles of CoPartnership. Form of the Articles. No particular form of words is necessary. A writing after the manner of an ordinary business letter is sufficient so long as it expresses the intentions of the parties. It may state 1. The name of the parties, 2. The business in which they are engaged, 3. The duration of the partnership, 4. The several amounts of money which the partners are to contribute, 5. The proportion of the profits and losses which each partner is to share and to bear, 6. The firm name, 7. The time which each partner is to devote to the business, 8. It may also define the duties and powers which each partner is to perform and have. There are many and various items which an attorney would insert if employed to draw the Articles of CoPartnership, which are not essential to the agreement. The main thing is to express the intentions of the parties, whatever they are. Let the student attempt a draft of Articles of CoPartnership. If the first trial does not cover the ground, the second may. Other provisions. The agreement may also provide for the various amounts which the partners may withdraw from the firm's cash for this individual living expenses. It may provide for books of account. It may provide for the dissolution of the partnership and for such other special agreements as the nature of the business may demand. Formation by oral agreement is as valid as by written agreement. The written agreement is resorted to merely for greater certainty and to avoid future misunderstanding and dispute. The partners may come together before embarking in business, talk the matter over, and come to a full understanding of what each is to do. They thereby form a valid partnership. Formation without express agreement. Partnerships are sometimes formed without either Articles of CoPartnership or oral agreement. This happens when two or more persons embark in any business or undertaking without having expressly formed a partnership in either of the ways previously mentioned. In such a case, the law implies a partnership and fixes the rights, duties, and liabilities of each partner. It is a partnership by implication. The law implies, among other things, that there are to bear the losses and divide the profits equally. If the amount of the profits and losses which each partner is to share and bear is not fixed by express agreement, it will be equal for each. The test of a copartnership. In case no Articles of CoPartnership have been made and signed, or in case there has been no express agreement for a copartnership, it is frequently a question whether persons engaging in a joint enterprise are copartners. The question is whether the acts of the parties result in a partnership by implication. If, in the conduct of the business, they have made a division of profits and mutually borne the losses, they are partners beyond question. That is a test. It is not necessary that they should all contribute money. One may contribute the entire capital, and the others contribute their skill and labor. Moreover, a division of the profits alone will not constitute them partners. An employee of a firm may receive a share of the profits as his compensation and yet not be a partner, if, besides sharing in the profits, he bears a proportion of the losses. He is a partner. Dormant and special partners. A dormant partner is one who contributes money to the partnership capital but is not publicly known as a partner. He is a concealed partner. If his connection with the firm becomes known, his liability is the same as that of the other partners, who are called the ostensible partners. A special partner is one who contributes a particular sum to a partnership business upon the agreement that he is only to be liable for the partnership debts to the amount of his contribution and to draw profits accordingly. The partnership thus formed as to the special partner is called a limited partnership. It is only possible in those states that have enacted a statute authorizing it. It is important to observe that if a person holds himself out or allows others to hold him out to the world as a joint trader or co-partner with such others, he will be liable as a partner to those with whom the others have dealings. Liability of the partners. As between themselves, the partners may agree upon the liability which each shall assume by entering the partnership. As to all other persons, however, all firms or persons with whom the partners transact business, each partner is individually liable for all the partnership indebtedness. Each partner is liable for any act of another partner performed in the due course of the partnership business. Each partner is liable for the act of any other partner which is within the power of the other partner to perform. This liability refers to all cases of a general partnership. It does not refer to that what has been termed a limited partnership. It is important, therefore, to know the power of a partner. Each partner has unlimited power to transact any business within the scope of the co-partnership, and by his acts he binds each of the other partners. It must be an act strictly within the scope of the partnership business. If a partner attempts to do something not within the scope of the partnership business, but outside of its objects and aims, he becomes personally liable, but does not render the other partners responsible. One partner may bind the firm by his admissions and declarations, by misrepresentation in the purchase or sale of property connected with the partnership business. He cannot use the property or credit of the firm for his individual benefit, and he cannot give the firm note for his individual debts. He may give the firm note for a firm debt, and even against the will of his partners, he may assign all the firm property in payment of a firm debt. Dissolution of the partnership. A partnership is dissolved, 1, by the expiration of the period agreed upon at the time it was formed, 2, by the mutual consent of all partners at any time thereafter, 3, by the act of one of the partners in making an assignment of his partnership interest, or in case no definite duration of partnership has been agreed upon, by his withdrawing or renouncing the partnership. 4, when an amicable dissolution cannot be had, by the decree of a court having jurisdiction on the ground of improper or fraudulent conduct on the part of one of the partners. 5, by the death, insanity, or bankruptcy of a partner. And 6, by the sale of a partner's interest after judgment against him, or by the happening of any other events which severs the unity of interest. The effect of dissolution. Immediately upon the dissolution occurring, and after the liquidation of the firm's indebtedness, either of the partners is entitled to an accounting and a distribution of the partnership property. One partner can no longer bind the other partners by any individual act, excepting such acts as are necessary to close up the partnership business. As to persons with whom a firm have been in the habit of dealing, however, one of the partners may have future dealings involving new business and new transactions, and thereby bind the others, providing notice of the dissolution has not been given. To avoid this, it is necessary and customary to give immediate notice of the dissolution to all persons with whom the firm has been accustomed to deal, both by publishing a notice of dissolution in the newspapers and by sending notice by mail.